Hello everyone, it's Sarah here from Activist Lawyer, recording in the Granite podcast studio in Newry. Thank you for tuning in again. So today we're joined by Kevin Winters of KRW Law, human rights lawyers based in Belfast. For those of you who don't know Kevin Winters, he's a leading human rights lawyer renowned for criminal defence, historical abuse cases, and probably widely known for handling and leading the way in many of the legacy cases particular to Northern Ireland and the Troubles here. This recording goes into detail around Kevin's work on very politically charged matters as well, like collusion and Article 2 right to life cases. For clarity, we'll publish a link on our website to Kevin's work and some of the cases he discusses. But we really would urge anyone interested in working in human rights and finding out more about solicitors who have been active in a post-conflict jurisdiction to really listen in. We really appreciate Kevin giving us such a candid, open and honest account of his career and his life in law, which is at times, I will say, quite harrowing and unnerving, but truly, truly fascinating. So I'd urge anyone to tune in. More of an introduction to Kevin Winters for anybody who is listening in. Kevin was apprenticed to criminal defence and human rights lawyer Patrick Finucane at the time of his murder in 1989. On Pat's death, Kevin went into partnership with Peter Madden and the late Eamon McMenamin. Kevin initially worked on the McCann and others versus UK shoot to kill death on the Rock inquests before the seminal case on the right to silence of Murray versus the UK. His criminal defence litigation in the 1990s contributed to the greater protection of the rights of people detained under terrorism provisions. Having forged his reputation in fighting miscarriages of justice in cases including the Ballymurphy 7 and the Beechmount 5, he went on to co-found Kevin R. Winters in 2001, which changed its name in 2012 to KRW Law, and it is Ireland's largest criminal law and human rights practice. Kevin's proven track record in judicial review applications has resulted in his Chambers and Partners Law Directory ranking in public and administrative law. His cases have embraced prisoners' rights, the right to march, political and sex discrimination and other equality issues. A new political climate in the jurisdiction following the Belfast Good Friday Agreement in 1998 has brought new challenges, resulting in the deployment of Kevin's skill set to a wider range of human rights issues, not the least of which has been conflict-related legacy litigation on behalf of the families of the victims and the survivors across the community, including former members of the security forces. The litigation department in his practice is unique in this respect, and its work on behalf of victims and survivors is informing engagement with other post-conflict transitional justice jurisdictions, which we will discuss today. In particular, this form of litigation being undertaken by Kevin and his colleagues challenges the failures of the British government to discharge its obligations following breaches of the right to life during the conflict. Kevin has pioneered the use of bespoke conflict-related legacy litigation strategies to address the ongoing truth recovery deficit for many bereaved families across the religious and political divide, and to call the British government to account for its failure to undertake independent investigations into the human rights violations suffered during the conflict. The range and breadth of instructions is testimony to his status as a leading advocate of an apolitical approach to what remains a serious human rights deficiency. Kevin is also a visiting speaker at the Institute of Professional Legal Studies of Queen's University Belfast, focusing on the management of a legal aid practice in fiscally straitened times. He is regularly requested to address Human Rights Forum, including the USA, having been nominated by the New York Senate for his contribution to human rights work, and more recently finds time from his busy schedule to assist as a legal advisor to the makers of the BBC drama series The Fall. Now, there's so much more to Kevin's work, but we will get to a lot of that in our recording today. So thank you, Kevin, for joining me today in the studio.
Thank you, Sarah, for the invite. I'm looking forward to it. My voice is a bit crackly with a heavy cold, so hopefully I'm audible to listeners. Thank you.
Oh, look, you're good enough to be here. Great to have you in person here in Newry as well. So we just had an introduction there, and I think maybe we'll go back in time just to, your early career, maybe as far back as to why law and what interested you in taking on a role in the legal world.
I suppose back in the day, I went to a local school here in St Coleman's, and I was pretty okay at the arts type subjects, had no clue in relation to science, etc. And you sort of found yourself gravitating to the type of areas of work that were arts based or whatever, if you want to put it that way. And going to St Coleman's, they tended to produce a lot of priests back in the day. And when I was about 13 years of age, for about 6 weeks, I dabbled with the notion,
Right.
and then soon lost it. But apart from that, there wasn't any real particular focus to become a solicitor or a lawyer. I'm like a lot of people of my vintage. They fell into it by default at times. So I went to study law at Queen's, and I really had no idea what type of area of law back in the late 1980s. You were just glad to get a job anywhere. But for some mad notion, I had this idea that I'd be a tax specialist. Where that came from, I've no idea. I often heard my mum and dad complain about tax, and I thought, this is something we should maybe look at. And I got an interview with a couple of places, didn't come to anything. And then I heard someone was about to be relieved of their duties in Madden and Finucane, and I should stick an application in there. And I did that. Was interviewed by Pat Finucane and Peter Madden. And they reminded me that there wasn't an awful lot of openings for tax specialists in the north of Ireland at that time. And so I ended up in Madden and Finucane, not really having any full idea of the type of work that would have been involved. Okay. So it was, I was soon to find out.
You were soon to find out. And I think it's fair to say that your apprenticeship, was pretty eventful and then quite unnerving. Maybe you want to share how you started off in...
Yes, I've spoken about this before, but the first few months was a really interesting introduction into my new world. First big case I can remember was the awful events of the 3 separate incidents, the killings in Gibraltar of 3 IRA volunteers. They were killed by the security forces. And their funerals at Milltown led to an attack, and a number of people were killed. One of those was Kevin Brady, who I had actually met out in Lisburn Magistrates Courts 3 days beforehand, before the Milltown attack. And then, of course, the terrible happenings of at the funeral of Kevin Brady, when 2 corporals were killed by a number of people, and that was my introduction into the new world of criminal law. And Pat then was representing one of the persons accused of the murder of the corporals, and I mean those were pretty grim times when you look back on them, and very, very intense, nerve-wracking. But that was my new world that I now found myself in. It was exciting, it was difficult, dangerous, different. And then I was sent over by the firm to attend the inquest at Gibraltar. It was running for a number of weeks. Paddy McGrory was the lead solicitor dealing with that. And I had looking back on it now, I had I suppose a career-defining moment. I would have been staying in a small hotel on the other side of the border in Spain, and you cross the border every day to and fro from the inquest. Gibraltar was a very heavily securitized state, heavy police, military presence everywhere, and obviously heightened because of the tensions around the inquest. And there was one particular day I was coming back from the inquest, and I was taken aside by non-uniformed security force personnel, and they took me into a booth and asked me my name and so on. They knew exactly who I was, and they told me to bend over, to bend forward. Had no idea what was happening, but soon realised. One of them then told me to take my trousers down and to remove my underwear. So I found myself prostrate, bent over a table in a booth, surrounded by heavily armed security personnel. Who they were, I have no idea, but there was 4 or 5 of them. Through the side of my eye, I could hear sniggering, and they very quickly told me to just pull my trousers up, and then said, "Off you go." That was a wake-up moment for me, and it was my introduction into a new world. And the the indignity and the embarrassment, if you like, of that has never left me.
Yeah.
Probably has been a formative influence on me in my later life and career, but it has stayed with me for a long time. So we moved from that to just a few months later to February 1989, and a moment that just will never leave me. And I got a phone call from Eamon McMenamin, who was one of my colleagues in Madden Finucane, and now sadly deceased. And Eamon phoned me after 7 o'clock on a Sunday night to say that Pat Finucane has just been shot dead. Those are the words. And then the horror of that, when people deal with horrible grief moments like that, it's like, I know it's such a cliche, but time does stand still.
Yeah, I'm sure.
And it was just awful. And then to go into work the next morning, and the stillness, secretaries crying, Peter, Pat's partner, had all that interfacing to do with everybody, so I was sitting in the office and wondering what was going to happen next.
Yeah.
I remember Barry McGrory, the former director of the DPP, coming in to see me, just to extend a hand of friendship and say, listen, anything that needed done. And you don't forget those moments.
No, I'm sure you don't. I can just imagine how unsettling, especially, and to go through those events so early on in your career. Would you say that it did inspire you to continue in that line of work? I'm sure others would be very much put off at those early stages,
yes.
But to work in that kind of very, very difficult, intense environment after having suffered trauma yourself, and with all of your colleagues in the same position.
Yeah.
How did you find, what inspired you, I suppose, to continue and to, build upon your work?
Well, to be honest, I think in the immediate aftermath there was a lot of insecurity. There was anxiety about what was to become of the firm, what was to become of me. I'd just been married with a young child, and the future was very, very uncertain. And but what kind of helped crystallised thoughts was, a few hours just on the Monday morning after Pat was killed, there was a county court appeal listed for hearing, and I sent a barrister up to make an application for an adjournment. And just assuming it was a box tick and that the adjournment would happen. It was a case, in fact, I'd been speaking with Pat about a few days beforehand, and he wasn't happy with me, and very unusual for Pat. He got a bit agitated and said, listen, I wasn't handling the case properly, I hadn't filed something in time, and there was an issue about the notice of appeal, etc. And incredibly, on the Monday afternoon, after the murder of Pat Finucane, the barrister told me to phone me to say that the judge had refused the adjournment.
My goodness.
And I was just simply staggered with that. A judge is now dead, but that has never left me. And was again another series of incidents and moments in the aftermath of Pat's killing, which helped form your view of what lay ahead. So it was a difficult time, and it was a small number of people there left to try and work our way through. But it was difficult, and it was a crossroads in my life. And Pat's killing was an inciting moment for me. What previously was a job overnight became a vocation, and has stayed with me ever since.
My goodness. And at that time, I suppose, we'll get to the current situation in terms of harassment and threats around lawyers, but you've really lived that from the very outset of your career. I know your office at the time was obviously very shaken, and the families of those involved and working there. But in general, what was the attitude like towards lawyers at that time, or people, a Pat, I suppose, as well? Is it similar to now, or was it much worse?
I look back at that time in the early 1990s when I was starting out on my career in the aftermath of Pat's killing, and it's almost like just a different world. And I look back on it almost like through a 3D perspective. And at times it's hard to believe that you did live through it, but you did. And it was intimidating. The standard work processes for me back then were Castlereagh Holding Centre, Longcash Prison and Crumlin Road Courthouse. That triumvirate of venues was to be the formative basis for my workload for the next 10 years. That was very intimidating. I was in Castlereagh very, very regularly, and the threats that had been issued to Pat before his death via interviewing officers persisted and continued. And you would have got third-hand comments from clients to say that things like Pat Finucane has been shot dead and removed. You're next.
Right.
Go and tell your solicitor, whoever comes up to see you, that they're next. And there was that kind of regular comment imparted to detained persons, and over a period of a number of years in the early to mid-1990s. Now, at that time, of course, solicitors didn't have permanent access to detained persons in holding centres. The full provisions of PACE regulations hadn't kicked in.
Okay.
And you saw your client in between the interviews.
Sure.
And that was all part of the interrogation process, also to undermine the confidence of the detained person as well, and to try and isolate them from the role of the solicitor and the advices that the solicitor might have been giving. So that was difficult. You would have been police stations to quite late at night, and on a weekly basis.
Yeah.
And there was no let up on that, because at that time in the early 90s we were at a peak time in the conflict here. When incidents were happening on an almost daily, weekly basis, and the workload that we were involved in reflected that as well.
Of course. So different times, but your workload, present day very much remains the same, in the sense that you've taken forward quite a lot of high profile cases, legacy cases, a lot of them based on, collusion matters, and we've seen kind of how inquests have evolved to present day. But just in terms of, again, bringing you back to those families that you work with as well, you've known them probably for decades now, bringing a lot of them through the courts and being able to institute litigation now to try and resolve some of these matters and to try and access truth or some level of closure for the families involved in conflict in Northern Ireland. But how do you see this whole process? It seems to be just a matter of re-traumatising, the victims and the families, and, very often with no end in sight. How do you view, your work is very much, intertwined with the political climate of the time, and it still continues to.
Yes, I mean, there was a political backdrop to the work back then in the 90s when I started out as a young lawyer, and there's obviously a very clear political backdrop today in relation to the work we'd be involved in over the last number of years, particularly with reference to legacy work. But just dwelling firstly on the political backdrop to the early 90s work, I mean, that sort of workload involved frontline agitation on various human rights issues. First of all, access to solicitors, the right to silence. One of my first cases was Murray versus the UK in 1981, which is a seminal European court ruling on the right to silence. And that arose out of one of my first Castlereagh arrests after Pat was killed. We also had applications for habeas corpus. We took cases in relation to detained persons been really, really badly beaten up, perforated eardrums, and so on. And we took judicial reviews. I was involved in one of the first judicial reviews in relation to contentious parades. I'll never forget it. It was a contentious march in Pomeroy in 1992, I think it was, and the Court of Appeal sat at midnight in relation to an adjudication on that. And all sorts of civil actions for false imprisonment, wrongful arrest, unlawful detention. We led the way. The fulcrum of that was at the head of that, almost, if you like, looking back on it now, I would describe Peter Madden as the godfather of human rights, if you like, given that the early gestation of what we have today, with a huge amount of people active in human rights. An awful lot of, in my view, the DNA genesis of that stemmed from those early days. And Eamon McManaman, who I cited earlier, and many people maybe don't know Eamon, who he was, but he was very much at the apex of civil litigation against state agencies, police and so on, and the MOD for human rights abuses and excesses. And there was no one like him. He really led the way, and I learned an awful lot from Peter and from Eamon in those days. And yes, they were difficult times and very strained times, and an awful lot of hostility to the work that you did back then.
Yeah.
I mean, political hostility. There was some huge amount, of course, policing hostility, and from other quarters as well. And so there was a backdrop of a stigma at times to the work that you were doing. Not everyone would have been supporting the type of work that you would have done then. And equally, ditto today 30 years
exactly.
on,
It hasn't
there's a lot
really
of political hostility to the work that goes on today.
And do you think, I mean, I'm not sure how to approach this question, but, you know, some kind of strategy behind that? I mean, the media seem to just have run with some, we'll get to that again a little bit later, just the specifics of some of the media attacks specifically towards, you know, your firm and other firms in Belfast. But in general, I mean, is this an attempt to maybe shut down the work that you're doing, to have these kind of orchestrated attacks and very real attacks and real threats, intimidation, harassment that has continued throughout your career? I mean, do you see a wider picture behind that, or, you know, personally, how do you feel about it?
The harassment, intimidation as such has evolved and changed. Back then, in the 90s, through it into the 2000s, and this has been the subject of some international human rights observations and reports and so on, which are well known in the public domain. That was outright harassment and death threats. I mean, we've received death threats. I've received death threats, and as have other people involved in this type of work back in the day. But the intimidation and harassment, if you like, has evolved into something quite different. It's reputational harassment, if you like, and cynical deployment of politics and media to undermine or attack the integrity of the work that you're doing. An awful lot of our work now over the last 10 years involves challenging the state over its role in the conflict. And we've been involved with a small number of other practitioners in steadily undermining and challenging settled, comfortable narratives about the conflict, i.e., 50% killings were Republican, 40% loyalist, 10% were security forces. And the litigation, whether via inquiries, inquests, civil actions, or the very small number of criminal investigations, has helped really undermine and turn those sort of statistics upside down. And there is a real backlash against that, and has been for a number of years. Yeah. In fact, it's almost a sort of a perverse backhanded compliment to the work that practitioners are doing in this field, that the government now wants to shut it all down. And the legacy bill introduced last year and working its way through Parliament is going to be, it looks like at some stage later this year, probably May or June of this year, will become law. Now, my view, I have a very cynical view about this, evolved over the last number of years, and it's because, as I've cited, the courts have demonstrated that they're fully independent and open for business in relation to legacy conflict-related matters, and that's something that the government doesn't have any control over. And I think they just don't like that, and they didn't see, I just don't think they ever saw coming the sheer level of and volume of cases brought, and let's not forget, the basis for that has been the doggedness and determination of families to want to see justice for their loved ones. And there has been systemic failings on a political level over the years, going right back, Eames Bradley, Haas Sullivan, we had Stormont House Agreement in 2014, and by and large, notwithstanding some logistical difficulties with these processes, by and large there was consensus, particularly in Stormont House Agreement, and yet we had that scrapped in 2020 to be replaced with this current proposal. So that political backlash is demonstrated on foot of the legacy bill, and we're right at the apex of that, trying to deal with that. And the courts and the sheer number of cases working through the courts, I think the British government has seen that that level of legal agitation as increasing over the next number of years, and they've decided enough's enough. They promote the legacy bill on the basis that it's to give families closure, that it's to give them transparency and openness in relation to what happened to their loved ones. But it's not the case. It's not families of victims centred at all.
It's not.
It's centred on perpetrators. And there's another serious, galling omission in the middle of all of this. Consistently, and we've seen this over the years with the production of various reports, the police response to, for example, hard-hitting police ombudsman's findings is to try and make it paramilitary-centric. And yes, of course, those were the people who planted bombs and pulled triggers. But, and it's a massive but, there are elements and a collusive element connected to the state behind an awful lot of atrocities, which always seems to get taken off the page when it comes to investigations. And I've listened again, right up to this morning's engagement, I've listened again to some of the political commentary about the legacy bill, and the consistent line put out is that it's to try and make perpetrators accountable, to the exclusion of the state. They forget that it's, or they don't forget, they know full well, but it's a deliberate removal of the state as a component in this, and that's completely abhorrent.
So a lot of, and that would force your hand and others to have initiated, groundbreaking litigation, I suppose, going back to the start of your career on behalf of these families. I imagine that a lot of that was quite unnerving at the time because it was quite novel ground, and perhaps you were uncertain as to where these cases were going to go. So it was ultimately a risk in taking a lot of these challenges. But ultimately, they have been groundbreaking, and in many cases, you had, really good outcomes. But I'm just thinking logistically, what were the challenges that lay ahead? Because we're in a very unique jurisdiction here, and even the likes of being funded seems quite a logistical challenge, perhaps, given that the actions are against the state. So how does it work, just in a very practical sense?
Yeah, it's a good question, and it's one that has always been at the foremost of my mind and colleagues over the years. I suppose the starting point for this was the production or the issuing of the Operation Ballast report by Nuala O'Loan, the former director of the Ombudsman's Office, Police Ombudsman. And once that report issued, we took a decision to take legal action, civil actions against the state over collusion, which was highlighted and cited in those reports. And the other case that started at that time was an investigation into atrocities like Loughin Island. I should say investigation by ourselves. Of course, there was no state investigation. And we filed a series of complaints and cases like Loughin Island and many others with the Ombudsman's Office. And I remember instructing a council to say, look, should we be looking at other ways of engaging on the current impasse on the conflict and how to resolve it and how to deal with it. The McCurr group of cases from 2001 and 2003 were a series of European Convention applications in relation to shoot to kill and other contentious killings brought before the European Court, and Britain was rightly condemned in those pursuant to those series of cases as not having complied with Article 2 of the Convention, the right to life and the right to a proper investigation into the taking of life. And the outworkings of those cases, there was a considerable delay on the part of the state, but eventually you had undertakings, promises, etc., to respond via the installation of the Ombudsman's Office, having inquests properly brought to deal with all of these cases, and eventually then the historical inquiries team. So these processes were put in place, but they were seen not to be moving quickly enough for families. And for example, in relation to the Police Ombudsman's Office, whenever the new Ombudsman came in, Al Hutchinson, his office, he was complaining that he didn't have the resources to deal with this. And there were other resourcing issues. So things moved at snail's pace, at such a slow pace, which was intolerable for families. So we decided that we would take a lateral approach to all of this and use the courts and make it court-centric, and actually to give families a chance to take control of it and have an input that they could handle along with their solicitors and supporting NGOs, rather than be completely reactive to the other processes supposedly put in place by the state. And that was the origin of, I suppose, our legacy litigation, and it involved taking a raft of cases, Article 2 themed judicial reviews before the High Court, which resulted in cases like the Hooded Men, the Bernard case in connection with the Glenanne series of killings in the mid-1970s, and many, many others. Including as well a case of James Martin, which was a challenge to the Ombudsman over the failure to investigate the outworkings of the what was called the Danny Morrison trial, and that eventually resulted in the appointment of John Boucher in the Operation Canova investigation into the alleged agent known as Steak Knife. So this was an example of court legal agitation via the use of public law remedies to try and achieve some form of transparency and openness for families and victims to engage on historic conflict-related matters. Yeah. That plus increased use of civil actions. The civil action in some ways was almost back in the day seen as the poor cousin of truth recovery legal processes. And I remember saying to colleagues back 10, 12 years ago, we're going to have to litigate the conflict. I know that sounds incredibly cynical and almost crass, especially when you're dealing with murders and the loss of life and loved ones trying to engage in a process. But this is a mercenary business when you're dealing with the British government and its state agencies. And it required an appropriate response. So we proactively engaged and started using tort actions. I have a sort of a quiet laugh to myself when I think about it, because I was one of the most useless tort students. I got barely scraped past 42%, I remember very well. And to find today that we're involved in all sorts of complex tort cases involving, for example, the tort of deceit, where an allegation that the government agency has held information back from families. And I mean, I mentioned Eamon McMenamin earlier. He was involved in one of the first ever collusion cases in relation to the loyalist agent Brian Nelson, and his role, along with the state, in the killing of a number of people, and he brought legal cases. And in that particular case, the case of Slane, Gerard Slane, we now found out a number of years later through the production of reports from John Stevens and so on, that information had been held back from the families in the original civil settlement. And we've now issued fresh proceedings. We also have the grounding tort of misfeasance, which is the tort, if you like, to cover the term collusion. We have conspiracy to kill. You have damages issues such as aggravated and exemplary damages, concepts involved in that, where you're trying to highlight and have a punitive, if you like, component to state accountability in cases. The concept of secondary victims, where someone came along and witnessed the atrocity, the killing of a loved one, and they arrive on the scene. And there's a raft of cases and new case law made in connection with that. And extra-jurisdictional issues, complex matters involving discovery, the whole notion of sensitive and non-sensitive discovery and how you process that through the courts. Sensitive discovery, which touches upon issues of national security, how that's all dealt with through closed measures proceedings under the Justice and Security Act. So there's a vast diaspora of civil litigation that covers the conflict. And all of that is still ongoing and continuing. But of course, as I've said earlier, the government wants to end all of that.
And just maybe two questions stemming from that. Even though you've brought it into a court-centric approach, you still, from what I can see, have to largely, there's real interfacing with various different agencies despite that. And I wonder, has it been your experience, the family's experience, victims' experience, that, the whole process has been frustrated depending on who's appointed to various roles, for example, police ombudsman, DPP, the various appointments of, commissioners and etc. throughout the time that have come and gone. Do you find that you still largely have to deal with, so many different agencies to affect the court work itself? And do you think that this could have been avoided in terms of the litigation, or was it inevitable that you had to do this to resolve the issue, or was there another solution in terms of government accountability?
Well, the starting point to answer that, Sarah, is the political process. And I've said this to so many families and addressed meetings on it. is that on one view, having to go and engage a solicitor ought not to have been on people's radar at all. The fact that you have to instruct a solicitor at all betrays the fact that there's a real sense of failure. These were and still are serious political issues and problems that ought to have been resolved politically. And it hasn't. And as I've cited earlier, there was a series of attempts which fizzled out. And the problem was that with those political failings, we have been left in a default position of having to litigate. And the second point I'd make is that the various agencies set up to deal with this have never been properly resourced. So the inquest process has never been resourced the way it should be. The Police Ombudsman's Office, the HET, I know there's differing views about the true worth of the HET. There were justified criticisms, but they did produce some significant reports, especially in the Glenanne series of cases, which helped form the basis of the Bernard Judicial Review. So the point is that the various agencies and structures in place post the McCare group of cases had to be engaged with and still have to be engaged with as a supplement, or if you like, to complement the legal processes that we're involved in. But if those agencies and if the processes had been completely resourced and fit for purpose, the need to take separate legal agitation would have diminished. The fact that those processes were completely poorly resourced and not fit for purpose at times led to an exponential increase in the need for legal agitation on behalf of families.
Sure. So that was the historical inquiries team that you referred to, and I think it ended in 2014.
2014, yeah.
So how would you, going forward or consider now, and I know the legacy bill, the government have their own kind of ideas as to a commissioner to deal with this, but do you think there is an appropriate agency now, or how would that look to you, maybe a standalone department, that would dedicate resources and time to this? What would be the way forward along with the litigation or in lieu of it?
Well, as I understand it, in the legacy bill, there's a proposed organisation called the ICRIR, and that it has been put forward as the answer, but it isn't. It's not going to be independent, and it's not going to be fit for purpose for the needs of families. Stormont House was an opportunity missed. Stormont House, the Historical Investigations Unit, the HIU, was the proposed model. Yes, it would have had some problems in relation to sensitive material, but there was always the option, and this is important in the context of what's been proposed today, where the government want to shut down the courts. At least with HIU, there still was the option of judicial agitation in the event that information was held back. As I understand it, the Secretary of State in that model had a veto over access to certain information, but at least a citizen, a family of a victim had the entitlement and the right of access to the court. That inalienable right of access to the court was still there within the Stormont House model, the HIU model, but of course it has been completely removed in the latest proposal. So any variation on what was originally proposed would be welcome, but it looks like that moment has long since passed, and we're now having to deal with what's on the table, which is this abhorrent legacy bill.
Unfortunate. Yeah. So the work you've done, we know a lot of the cases, high profile, shown around the world, and exemplary work. Ballymurphy, a lot of the Bloody Sunday cases that arose. So do you think it's unique to Northern Ireland that lawyers have commenced really groundbreaking work on legacy and kind of post-conflict issues? And how might this have influenced other jurisdictions around the world, if at all, if you're aware of it?
I think in many ways, practitioners here involved in legacy conflict work have actually, and I don't want to sound boastful or anything, but I think we've led the way in terms of accessing the courts. I'm not quite sure, and I've looked at other jurisdictions, I'm not quite sure there has been the same level of engagement with courts, especially on civil actions, on tort actions in other jurisdictions. And I remember looking at the Whitey Bulger case in Boston. And Whitey Bulger was an agent of the FBI and the police in Boston, and an Irish-American high-profile figure of ill repute, and he was involved in killings and other criminal terrorist activity whilst he was an agent. And I remember reading that a number of families of his victims filed lawsuits in Boston, and in America there's a very stringent statute of limitations, which said that you had to take your case within 1 year of the incident.
Within 1 year.
And the problem there was that the families were saying, but look, hang on a minute, we didn't know that this guy was an agent, and we only upon realisation of his true status were we in a position to take these cases. But incredibly, the courts struck them out as out of time. To my mind, that looked like a political decision. Point being is that it's in marked contrast to the flexibility shown by the courts here on limitation, and that's absolutely vital when we look back at the history of conflict legacy litigation in this jurisdiction, is that under Article 50 the courts has a discretion to extend the limitation period, and after a series of battles fought actually more so in relation to the context of historical abuse cases. There's been at least 3 cases we were involved in, and regrettably we lost 3 cases on limitation on historic abuse, and it didn't set a good template going forward for conflict-related litigation. But thankfully, those cases were seen for what they were, which were very, very fact-specific, and the jurisdiction has been really open for business on the limitation issue on both historic abuse litigation and on conflict litigation. And so to this point today, in 2023, we're in a very, very mature position. I'm not so sure that is quite the same position in other jurisdictions dealing with a post-conflict scenario. We've engaged with people from Argentina. I met an Argentinian lawyer just a few weeks ago who was very interested in the work that goes on here in this jurisdiction, because they didn't have quite the same engagement in the civil courts in dealing with some of the historic abuses perpetrated by the state in the 1970s and early 1980s. There was the former Yugoslavia. Again, they have had war crimes tribunals set up to deal with a lot of this, but the concept of civil litigation against the state doesn't seem, subject to correction elsewhere, doesn't seem to have evolved to the same extent as it has here. So in many ways, I think people and folk involved in legacy issues here have forged a new path.
Fantastic. So taking a quick break here to say that I hope you're enjoying this episode of Activist Lawyer. Again, we'd be grateful if you could like, share and review the podcast, and please check out our website at www.activistlawyer.com, where you will find some Activist Lawyer branded merchandise and some blog articles. Please tune in on Apple, Spotify or the platform of your choice for more great episodes coming soon. And just in terms of, I suppose you've so many cases that you've been involved in over the years, but what do you feel stands out for you as maybe a defining moment, either personally in your career or with your team at KRW? Is there anything that you would look back and say, we really achieved a great outcome there and we're really proud of that piece of work?
Well, there's a series of cases. You're always loath to identify just one case.
Yeah, of course.
And there's a raft of cases. The work done on Loughlin Island, in conjunction with journalists in the production of the film No Stone Unturned. And that's a classic example of journalistic and legal and NGO agitation working together and using both legal processes and the media in a very strong, powerful way and a linked up way, and sends out a powerful message. We've had a number of cases taken to extend this whole traditional notion about collusion, that it was very much loyalist, state-centric, I think is now outdated. And I think collectively all of the cases taken point to consistently highlighting the role of the state right across the board. And in fact, we're sitting here in Newry, which is the basis for a raft of cases during the conflict, which are now playing through the courts, involving allegations of Republican state collusion, and some of the atrocities, killings perpetrated here, and other terrorist incidents involving one or two agents within the IRA in South Down in the 80s and 1990s are now being played out through the courts. We have a total of 28 cases arising out of incidents that happened here in Newry and South Down from the late 80s and early 1990s, all involving allegations of state penetration of the IRA here and the use of an agent who's well known. In fact, he has admitted himself in his book that he had such status. I don't want to go into any more detail because that is actually the subject of pending further litigation and judicial review. I think collectively all of those cases which have forced the government to the point through work of ourselves and a small number of other firms in the north dealing with this sort of work, that it has brought the British government to this incredibly draconian position to say we're shutting down the courts and we're denying access for families. I mean, the more I think about it, it's depressing. I get angered about it. I'm trying to look at ways to circumnavigate it. And when I stand back and look at it and see that we're almost sleepwalking into this position where it's somehow going to happen, that the courts are saying, that the government is saying, you can't access the courts. Now, when I mentioned earlier about being a student and doing law at Queen's, the notion back then that you would, in your later career involved in cases, have to deal with a concept whereby there's a piece of legislation that says you are not allowed to litigate these type of cases. I mean, it's something more akin to some sort of third world dictatorship, but yet it's happening here in a modern Western democracy.
And of course, their proposals impact all aspects of community here. It's not just one-sided approach. Everybody who has suffered will, continue to play a victim if their proposal goes ahead. And I guess on that point as well, and I know, you've received a serious amount of criticism, mostly from publications, the lovely tabloids that we're all familiar with. But do you sense that they portray you as maybe a one-sided firm, you and the other practices in Belfast? And, how do you, respond to that?
Yeah, it's pretty grim, but we've had to take litigation, we've had to take defamation cases successfully against the Mail on Sunday, against the Sunday Times. We've been described as legal auxiliaries of the IRA in the context of the Hooded Men. We've been described as being involved in witch hunts and in taking cases without merit by the Mail on Sunday. They apologised and paid out damages, and regrettably and unfortunately we have another case pending on the 20th of February this month. I myself present as a plaintiff in my own libel case along with my colleagues, my partners, in an action against the Sun newspaper for an article in November 2016 where they described us as being involved in a witch hunt against the British Army and using taxpayers' money, legal aid, to take these vexatious cases, that we're Republican linked and that the actions that we're doing have no merit. I get angry about that. And in this business and the work that we do, solicitors generally, and particularly the type of work that we're involved in, reputation is everything. And whenever there are challenges made like this to your reputation, it's galling, it's depressing. You just wonder how deep-rooted it is. You think of the people who might otherwise have wanted to retain your services, who may not have done so because they have looked at this type of appalling use of offensive language. But again, it's a cynical view that I have. I don't think that a journalist in the Sun newspaper woke up one morning and decided to attack my firm and two other firms who are cited in that article and have a go at us. I think there's other deeper engagement involved with the state. What it is, I don't know.
Yeah.
I remember being at mediation, confronting 3 journalists from the Sun, and I put that to them, but they sat stony-faced. The silence, I suppose, was tantamount to a denial that there was any kind of state military intelligence backdrop to the briefing to attack the firm. But of course, what we now know is with the 2 things. One, the attacks made by successive secretaries of state. Theresa Villiers used the term pernicious narrative being perpetrated by lawyers. And then more latterly, Brandon Lewis, whilst not naming us, did describe the work of lawyers involved in this area in very offensive terms, to the point today that we have now issued separate defamation proceedings against Brandon Lewis. So the collective outworking of all of this, I think this was all part of a choreography. I think it was setting the tone and putting in place a template for the later legacy bill, is to demonise those involved on the front line in taking these sort of cases. And the best thing to try to undermine the integrity of you do is to describe you in these sort of derogatory terms, because the perception would be that somehow then undermines the quality of and integrity of the work that you're doing, the credibility of the work that you're doing, and in turn using that to feed into the type of narrative that has been perpetrated with the legacy bill, which is that this is centric on challenging ex-members of the British Army, ex-members of the security forces for criminal prosecution. And it is a complete misnomer. It is just nonsense to suggest that there were going to be hundreds and hundreds of criminal cases involving ex-members of the security forces. You could count the number of cases on one hand. They're well known, the likes of J.P. Cunningham case, the Joe McCann case, Bloody Sunday cases, and these cases are small as a proportion of the overall number of criminal cases and killings. They're incredibly small. Yet that was put forward as a prime basis as to why a legacy bill was needed. The real reasons are, and I've discussed them already, and I'll emphasise them again, the real reasons for this was the role of the state right across the board, not just with loyalists, but also with Republicans.
Sure.
And that, I think, was reaching a critical mass in the courts. And the men in dark suits who David Cameron spoke of when refusing the Finucans their inquiry, I think have a hand to play in all of this. The extent to which they've been involved in perpetrating the immediate offensive on us, I don't know, maybe time will tell, but there's certainly the hand of the state, the deep state, is involved in this legacy bill.
And I mean, I know some of the documents that I've looked at and that you've shared with me as well show, a level of support internationally for lawyers, particularly from the United States, who were involved in a lot of the, the formation of the Good Friday Agreement. But I just find it interesting that some of it pinpoints a lot of this to 2016, when there was a surge in attacks. And it was taken from something that Theresa May, who was Prime Minister at the time, had said in relation to, I think, Afghanistan and Iraq. However, the tabloids took it, twisted it and applied it here verbatim, pretty much, where she had mentioned about the activist left-wing human rights lawyers who were haranguing and harassing British military personnel, tank-chasing lawyers and everything else that you've just described, fat cat lawyers, then witch hunts was mentioned as well. It just seems incredible that somebody in that high position, public position, could, has taken it upon themselves to really damage the legal process here and across, the UK. It really is so, I don't know, it beggars belief that still continues to happen to this day. And just to put it in context, it's something interesting here is the UN basic principles and the role of lawyers, again mentioned in one of the articles that you sent to me, was that lawyers are able to perform all of their professional functions without intimidation, hindrance, harassment or improper interference, and not be identified with their clients or their clients' causes as a result of discharging their functions. I mean, that just seems to be blown out of the water and continues to do so to this day. So I know we'll focus on, your case coming up with the Sun again. And I think the level of intimidation and harassment was really deep in terms of, some of your partners in the firm as well. You've expressed there that, you're personally, it makes you extremely angry. But how does it affect, the day-to-day work? Do you feel that people maybe are reluctant to approach your firm or your practice because of this kind of level of, misrepresentation, to such a high level?
I suppose going back to the time of Pat's killing, as I've highlighted earlier, my working practice and my day-to-day working practice, I was always very security conscious, and I knew how to check my car for devices. I changed my name. I changed my routine. I was very careful and circumspect about where I was going. and that kind of imprint is still on me.
Yeah.
And you could call it paranoia, but I mean, I have a reason for that. And that paranoia still exists today. So when I see this type of attack, and you've cited there Theresa May describing the work of lawyers as tank chasing and so on, that kind of imprint from those early 1990s days is still with me. And so I'm alive, and maybe forgive me for being oversensitive to it, but I have a reason for that.
Yeah.
And I mean, of course, let's not forget, 10 years later after the murder of Pat, we had the terrible atrocity and the murder of Rosemary Nelson. And I remember seeing Rosemary about 3 weeks before she was killed. I went in to her office. She was actually in touch with me about how to fill in certain claim forms. I know it sounds incredibly dull and bland, but I was engaging with her on basic business issues like that. Called in to see her, and I remember at the time feeling a sense of her vulnerability, because I was able to walk up the stairs in her office, and walked into her office with piles of files behind a fog of smoke. She was a heavy smoker, Rosemary, and I said, Rosemary, look, I've come in here just, willy-nilly off the street, and and she just shrugged it off. And 3 weeks later, she was blowing up, and so. And I remember not long after Pat was killed, an old sage of a client said to me, Kevin, there'll never be another solicitor murdered in this jurisdiction. And I remember thinking at the time, well, he's right. Nothing could ever like this happen again. But it did happen again. It happened with the murder of Rosemary after the Good Friday Agreement. I mean, it's appalling. And 2 months after Rosemary's killing, the Law Society met and had an extraordinary general meeting, one of the first times, in fact, that ever happened. And there was a resolution passed about the need to have inquiries into both the killings. And that's over, it's only 23, 24 years ago.
Yeah.
But the type, so I have an inbuilt kind of anxiety about what the state is capable of.
Yeah.
But it's because I come from that background. To many people that might seem as just a bit mad, but I get to say that.
I mean, you'd see, people saying, it's alarmist, but when you've witnessed that for yourself on 2 occasions, and we're also reminded of the likes of the MP, Joe Cox as well, who was a victim of far-right extreme violence that was perpetrated by media articles as well. I mean, a lot of it is intertwined, and not only is it an attack on the rule of law and lawyers, but very importantly on peace here. Do you think this type of almost encouragement from the state to allow the media to have a free run at lawyers, without really a second thought to their safety and their families and how they feel and how members of their firm feels as well, does it lead to instability on a wider basis, do you think, or do you think it can be contained?
Well, it has been happening and is happening, and I'm dealing with it in a few weeks' time in the High Court. But for example, the lazy use of journalism such as Republican linked, that has a horrible chime back to the appalling words of Douglas Hogg, the junior minister, 3 weeks before Pat was killed, that with regret he said that some lawyers, regrettably, had sympathies with the IRA. And that, if you like, is almost a modern day reincarnation of that type of syntax used in the newspapers. And it's very, very dangerous. I mean, yes, it's 25 years on from the Good Friday Agreement. There have been massive political and security advances. I mean, it's a completely different world that we have now, today, than the world that I existed in before then, practicing law. But there's still a residue of the old past that's here. There are still threats. There are still people in society here who are dangerous, and this type of commentary is dangerous. And it's whether or not there any foresight on the consequences of it have been properly given, I don't know. But it's certainly very, very annoying and causes us all to be extremely angry, and immediately when I read those sort of words, I'm taken right back to those dim and dark times of practicing in the 90s, when you were dealing with threats of the type that I've talked about.
Yeah, and it's almost, I mean, their justification is that lawyers here are attempting to rewrite, you know, history and create their own version of events. You know, and exploiting a lot of the families for financial gain, which of course, as you know, with the really in-depth and heavy workload that this involves, runs counter to that. But yeah, I mean, we could go on and on about the threats, and they still seem to continue. We did have, I know you'd probably be aware, Colin Harvey, who's an academic, Professor Colin Harvey in Queen's University, has been very outspoken recently, and as an academic who is involved in discussing, you know, Ireland's future and constitutional issues here, you know, is subject to a barrage of abuse daily, it seems, online, so that the abuse, people are more accessible in terms of getting at somebody. And I mean, I'm sure, you know, I don't know whether, I'm guessing you'd receive comments or emails from individuals, not alone just the media, you know, maybe encouraged disgustingly by the state. You know, I mean, can it come to an end? Hopefully your case, you know, coming up in February will draw some sort of conclusion.
We regularly get all sorts of interesting social media commentary on the back of a court case. I keep all the interesting negative social media. In fact, I've printed off some of them, and we're in the process of getting them framed and displaying in our office. So we kind of wear them as a sort of a badge and say, listen, you know, throw it at us.
Yeah.
We actually turn it into a negative comment is turned into a positive, and it just, that type of commentary, social media or otherwise, and it's all pervasive now. It's the world that we live in. You use that to inspire rather than to make you run away from it, you know.
Yeah.
So, I mean, it is what it is, and we don't give it any credence whatsoever. But you're quite right, Colin Harvey, who's a client of the practice, has been subject to some horrendous online abuse. And all of us involved in this sort of work, in human rights work, of course, would say that everyone has an opinion, everyone is entitled to have their opinion and to display it, but not to the point where our lines are crossed and it creates a threatening environment. That's just inexcusable, and those people perpetrating that type of commentary ought to know better.
Yeah, well, I suppose it's one of the reasons we had looked at setting up this podcast of the last couple of years, seeing the barrage of online abuse, but you always see that it's encouraged by high-ranking members of the government, which is very worrying and continues to do so to this day. But just leaving that aside for a moment and going back a little bit in time, just to you opening your own practice, I mean, what encouraged you or inspired you to do that at that time, and how did it work in logistically and, you know, with your staff, etc.?
Yeah, well, I think we're now 21 years in existence, and we started off primarily as a criminal law practice. About 60-70% of the work would have been crime, and at that time, 2001, there was still a lot of heavy criminal work involved in the courts, some 2 or 3 years after the Good Friday Agreement. And I know we had the various ceasefires and so on, but there was still the outworkings of the political process still lent itself to a lot of heavy criminal work. And we were involved in some significant cases, the Northern Bank robbery, for example, and the Robert McCartney murder case, the Oma bomb trial, both criminal and civil. And all of these cases were taking place in the 2000s, but I suppose one of the first cases that I was involved in after the formation of the office was the Stormont Gate affair, if you like, where Stormont was collapsed on the back of an allegation of an IRS spy ring and the recovery of documents. But what we now know, of course, is that this was a contrived prosecution undertaken for wider, complex political and security force agendas at play, and involving a certain dysfunctionality within policing, etc. And that was played out via this court case, and it led to the unmasking of of an agent, Dennis Donaldson. And I suppose just touching on that, and the work that I was doing in the 1990s in criminal cases, political trials, etc. We now know that at times in some of these cases, and it's not just in relation to civil actions, but also in criminal cases too, where there would have been a separate, almost like a parallel world existing, where you'd have intelligence matters, satellite files, etc., handed into the court, which the defence would not have been party to. And the Stormont case, it was, I suppose, at the apex of that type of case, because the disclosure process in the criminal trial flushed out the existence of an agent who was one of the people appearing in the dock. And I've no doubt, going back to the 90s and the repeat applications for what were called public interest immunity applications, public interest immunity certificates, which were made in many, many cases, all pointed to the existence of an intelligence agenda underpinning a certain number of cases. But none of that has seen the light of day. More laterally, a lot of the trials we were involved in the 2000s did in fact touch upon that, and did expose, such as the Stormont case, the existence of agents and informants in different cases. So that was the world that we inhabited for the first number of years, and then that evolved and morphed into all sorts of other work.
Largely human rights based.
Human rights based, yes. And so to the point today that a significant portfolio of our work straddles all sorts of different strata. So if you like, that criminal, the work and experience in criminal litigation, compounded by civil litigation and human rights agitation, has evolved and morphed into our getting instruction from all sorts of other areas that we hitherto would never have ever seen.
So the skills and I suppose the expertise that you develop there can, translate or transfer, I guess,
completely
over to
transferable into other areas. And so, for example, we're involved in cases. I suppose the cases that other people don't want to do at times, and we've seen that especially in the Republic of Ireland. I mean, we're involved. I mean, if you'd said to me 10 years ago, we'd be involved in taking on one of Ireland's, if not the biggest, stock-listed company, CRH Roadstone, on €150 million commercial action for alleged cartel price fixing in the concrete industry, I would have said, no, that's not for us. That's for one of the big commercial law firms, not a human rights criminal law firm. So the skill sets, the template, the mantra, if you like, the in-house that we have in those traditional areas are equally transferable to all sorts of other legal arenas that we would never have usually been involved in.
Yeah, brilliant. And do you think your initial kind of interest in the financial world, enables you to, I suppose, manage the business side of things too? Because obviously not only are you responsible for this, intense and heavy caseload and attracting new areas of work, etc., but it is a business essentially that needs to be managed and run efficiently. And you do have quite a significant number of staff, 44, 45?
Yeah, we're 45. At one point we had over 50 with 3 different offices, and then we rationalised it into one office based in Belfast. And I suppose the modern world you live in now, you don't need to have a physical presence in location A, B and C. Instructions can be taken anywhere throughout the world, and indeed we have taken instructions from outside the jurisdiction in many ways. But on a business front, dealing with this sort of work, dealing with legal aid, human rights, traditionally that is seen as the kind of almost like the poor man's sort of law firm, but and I rail against that. To do human rights work, to do this sort of work properly, there has to obviously be a business base to it, and if you don't have that, then nothing gets done. And I mean, I know it might sound incredibly dull, bland, and boring to many, but it's about valuing your time and valuing your work. So if you're working on a case, it's to put a value in that, and it has to be accounted for, and. Thankfully, we have a very fit-for-purpose legal services agency who have been very supportive throughout the years, and I have to say, and take this opportunity to commend them for the assistance they gave during the COVID era to our type of work and legal aid. really stepped up to the plate and helped practices navigate their way through that difficult time. But it extends further back from that and going forward. I've found the LSA has been very flexible and receptive to the type of work that we're doing. Yes, you have to make your case. It's like anything. It's the strength of your case and how you articulate it and advocate it. You have to do that. So the team are on message about what's needed to be done in relation to progressing a case and taking an action. We have sophisticated business processes in place. We're Lexel compliant. We've just come through a Lexel inspection the other day, and it can be a tough journey into that, where the office is on a kind of a war mode alert to get everything, get files in place, and people have to be interviewed. It's a tough gig, but you know what? It's worth it, and I would thoroughly recommend it to any other practices involved in this sort of work. You step up to the plate, and it makes you think about what you're doing. What are you doing in your business, and how are you doing it? As I understand it, we're one of 13 practices that are Lexel compliant in this jurisdiction, and I can't commend it enough to do it and to put the sweat in. So yes. The nuts and bolts, the basics of it are billing and understanding and how to record your time, how to process that, how to stand over it if you're in front of a taxing master, is how do you have to be able to say, I did this work for the following reason. I know it sounds incredibly basic, but it is. If you get the basics right like that, then you're on a right footing. And sometimes I find young people coming through law school, coming in from university, and they have fantastic aspirations to do the work of lawyers and are greatly driven to be lawyers. But it's important at all times to recognise you need to be tax savvy, you need to understand VAT, you need to understand accounts, you need to understand the business of how law runs. And if you do that, I think you're a better lawyer. I think you're a better human rights lawyer. I think you're a better activist lawyer the more that you're able to do that.
And just on the approach to your work, you've touched on it, that you don't see it as a job, it's a vocation, and that's very, very clear. But how do you separate your day-to-day life, your family from that work? Is there an off switch ever, or is it always just there in the background? What do you do to switch off, if you do?
I don't switch off. I'm always on message. But I absolutely love what I do. As I've outlined, I like to think I'm driven for certain deeply personal reasons.
Sure.
And I know I'm going to bore you now by saying that an awful lot of it does come back to your childhood and family background. I mean, my mother and father put me onto a building site when I was age 10. So every summer from age 10, I worked in a building site, getting up at 5:30 in the morning, making my packed lunch. I still get up at that time, and I still make my packed lunch. And off I go. And if I'm in after 7, I feel the day has run away from me. And but I found myself running into the office at times. I can't wait to get in, to get started. I have as much enthusiasm now for the work that I do as I did when I started. I don't see that evaporating or lessening any time soon. I feel that there's so much to be done. I get frustrated at not having enough hours in the day. Yes, I do have family. Yes, I do have a social life. Yes, I have played sport and so on. And that's important as well. It's an important complement. I do all the basic stuff that other people do. But I like to maximise my day. There's no time spent dawdling about reading newspapers and long lunches. It's full on because, quite simply, I enjoy the work. I enjoy the challenges. And yes, every single day there are massive hassles and difficulties and trials and tribulations, disgruntled clients, disgruntled colleagues, disgruntled others. You're fighting with people, you're on a war front, you're agitating on all sorts of issues. There's not a single day goes by that runs smoothly. But, as I said in the Godfather film, Michael, it's the business we chose to be in, and it's the business that I chose to be in, and I'm still in it.
And with that business that you chose to be in, what advice would you have for anybody who would like to get into that area of work, even practically speaking?
I think it's empathy. I know it sounds so basic, but if you have empathy for people, and listening to their problems. I always say, if you look after the small cases, the big ones will come. Yeah. So if you have a client who comes in, and I keep saying this, and I try to rail against it, I keep saying this to staff and colleagues, no case is too big or too small, and no case is so small that you just turn it away. To that person, that small case that you might take it to be, it's their life, you know. Yeah. So, for example, we would regularly have clients who have maybe had their shoes or their jeans taken off them during a police search, and they want those pair of jeans, and they want that computer returned, and they want their trousers returned, because it might be the only pair of trousers that they have. Yeah. And to the outside eye, that might seem like a really nothing matter, but to that person, it's so important. So if you manage to recover those items of property for that person, you have a very, very loyal client who may have some other instruction of great significance. So if you're interested in competing and have empathy for that person and their issue, and has the enthusiasm to see it through, that's really important. I think if you just look at it as just something, as a nuisance, or that, you know, as a box tick you have to get out of the road for the day, it's not going to work for you. You may go and do something else. Nice. I think you have to embrace the client's concerns and worries and anxieties, subsume them, and try to offer a way through. If you're interested in resolution of difficulties and problems, no matter what they are, if you're interested in the fight, you have to be competitive. It is a competitive world, competitive on all sorts of fronts, three-dimensional front, competitive and difficult and complex of the type that I've talked about. But I think if you're hot-wired that way to compete, and you have that empathy and that passion, this has all been said before by others more eminent than me, but I think that's very important.
Yeah. Excellent advice. And just finally, I guess, the question that we ask everybody is, how do you view the role of the law and activism, and can activism and the law together make change in society that we need?
Yes, I think activism and law, engaging with other parties and being alive to the endless possibilities of the work that you're doing, has never been more important today. You know, we've come out of a conflict society and we're still dealing post-conflict, but there's still so many challenges there. And of course, human rights work straddles all sorts of different terrain. It's not just, sometimes people look at human rights and there's this lazy view that it's to do with prisoners or people charged with criminal offences, and that's somehow human rights. Of course, we know it isn't. It's in equality issues, sexuality issues, education, health, and discriminatory issues. You know, it extends so far and wide. And I think a good grounding for someone wanting to be activist in this area is to have an understanding of the Human Rights Act and its clout, its reach, and it straddles so many areas of life. I mean, one of the big things at the minute that our firm is dealing with is healthcare deficiencies, mental health deficiencies. We have a judicial review pending in the High Court at the minute for the key issue of the lack of oversight for complaints in relation to the provision of mental health care. There is none in this jurisdiction, unlike England and Wales, and that's a massive gap that exists here. Human rights legislation, human rights issues permeate so many different strata, and I think having an awareness of that, and having, I think it's important as well not to hide your light under a bushel. I think it is important to engage with media and forum like this, the podcast, very, very important. It's not just to do the case, but to make sure that the impact of that case has been made known to the wider world. Traditionally in the past, law cases, results, judgments, etc., were the preserve of the lawyers. But we live in a completely different world now, where people have access to outcomes within seconds. You don't have to go and buy a newspaper. Those eras are long since gone. And getting your message out, getting the result, can create impact, and it's part of the activist process, in my view.
Okay, well, Kevin Winters, thank you so much for joining me today. It's been a pleasure.
Thank you.
Thanks everyone for joining me today. If you like the show, please remember to share and leave a review if you have a moment. And you can also check out our website, www.activistlawyer.com, where you will see some blog articles written by our guests and contributors, as well as some fabulous Activist Lawyer merchandise.
This podcast was recorded in Granite Podcast Studio. Interested in starting up your own podcast but don't know how? Granite Podcast Studio can help. Record your podcast in our state-of-the-art studio, which is based in the heart of Newry City. Our studio has cutting-edge and user-friendly technology and can seat up to 4 people. We also provide an editing service, where our team using your guidance and editing notes to provide you with a flawless finished product, leaving your listeners wanting more. For more information on how you can get started, visit www.granitepodcaststudio.com.